Plaintiff.
Precious Martin for the defendant, Johnny Dupree. No opposition from the defendant. From defendant Dupree on merging those two lawsuits.
Thank you.
Thank you.
Malcolm Jones, Mr. Ware. Your Honor, on the motion to consolidate, am I to understand that you wish to consolidate Mr. Jordan's petition with us, with the Ware case, and have it heard at the same time?
Yes, sir.
Will you bifurcate any portion of the trial, or will it be done exactly at the same time with the same jury?
Thank you.
Same time, same jury?
Yes, sir.
Based upon that, Your Honor, we believe that under Rule 42 of the Rule of Civil Procedure dealing with consolidation, that we do not have the same common issues. Mr. Jordan has in fact raised a federal question, issued his petition having to do with the Voting Rights Act. That is not something that we have alleged at all. It's a big portion of his petition. And in fact, the issues that he raised were actually totally different from the issues that we have raised. And so we would submit that there are not common issues, and we do not believe that it will create a clear case for the jury to resolve. Specifically, we would point out that our contest is more about the handling of absentee ballots and some affidavit ballots and some other issues. His has to do more with problems with the voting machines themselves.
And also, his name off the voting ballot, sir.
Right.
Precinct.
Yes. So,
You know, I think that the alleged improper use of the machine should be settled at the same time. The common ground there, all your stated opposition to the election. We will see them. Now, there was next item, we have a motion. Motion for some payments. Motion to reserve record and so forth.
sorry, Your Honor, I was having a little trouble hearing you. Did you want me to go ahead and bring up the motions that we followed? Yes, sir.
Yes.
All right. Excuse me. The first motion was for the issuance of subpoenas. As you're aware of the rules of subpoenas and the response time, we need to request the court to shorten the time to allow us to have the information available by the time we have our trial set. If we don't do that, then the persons that are responding, which are not parties to the suit, can take the full amount that's allowable by statute and by the rules, Rule 45, and we will not have it in time for the hearing date that the court has set. So we require that information to be able to show how certain ballots were handled and how certain city employees acted during the course of the election, both prior and after the election occurred.
I believe you also made mention, I'm going to the minute right now.
Yes, sir.
Looking at the file. How about some action to preserve records?
Correct. Yes, that's actually a different motion, but as to the motion, this is for subpoenaing the cell phone records. Your Honor, do you have our motions available to you? If not, I can bring you copies right
Yes,
now.
I have the file.
Do you have it available?
Yes, sir.
Okay. So that is the purpose of that motion, is to shorten the time, because otherwise the third party, the telephone carriers, could take the full amount of time that's available to respond under Rule 45. And all we're doing is asking to ensure that they're going to have that information available at the time the case is set for trial. As you know, we're on an expedited schedule. May I move to the next motion?
Yes, we also got a motion to open the ballot.
Yes, sir. But before I get to that, you asked me about the motion to preserve the video. There are certain closed circuit television video that is taken in the city hall at certain locations where absentee balloting occurred and other activities that pertain to the balloting process. video machine actually erases the tapes after a certain period of time. We want to make sure that that video is being maintained by the city and not inadvertently erased. So we have asked, because there are certain points that we want to show about one particular person claimed to have voted, but yet his ballot does not show anywhere in the materials. So we're asking the court to direct the city to ensure that the video is preserved. The third has to do with the ballot boxes. Your Honor, there are quite a few, as you read our petition, absentee ballots and other ballots that are in question, and we're going to have to literally go in there and copy all of those to be able to have them available as trial exhibits. We went into the examination process. Other people handled the examination. At the time they did the examination, they requested to be allowed to make copies, but the city, upon consultation, I believe, with the Attorney General's office and the Secretary of State, said that it was not appropriate to make copies at that time. To promote judicial economy and let this case move along as it should, not have long delays, we would like to be able to go into the ballot box in the presence of the clerk with other candidates and council president from Mr. Dupree, so that we can make those copies, have them prepared, pre-marked, and when we show up to have our trial, we can have a trial and not have to go through hours of going through the ballot boxes and introducing, taking the information out and making copies to introduce the trial. Some exhibits will actually be the actual election materials, the originals, where the copies won't show the detail that we want to show. So we need to have that as a housekeeping measure. Have the court establish a time with the clerk, the city clerk, that we can go into the boxes, make the copies, prepare, and be ready. And of course, obviously, the opposing attorneys and their client will be available at the same time to do the same thing if they choose to do so.
Yes. I won't belabor the points, but the court is intimately familiar with Rule 26 of the Mississippi Rules of Civil Procedure, which states that a party may obtain discovery regarding any matter not privileged which is relevant to the issues raised by the claims or defenses of the parties. The first subpoena that they've issued is for some cell phone records. The motion simply asks the court to require the cell phone carrier to shorten the amount of time needed to respond to the subpoena. There is no indication in this request as to what these cell phone numbers, how they are at all relevant to the claims and defenses of the parties. They should not be allowed, because this is counted in terms of an election contest, to conduct a fishing expedition. These cell phone numbers, we don't know who these cell phone numbers from their document, who these cell phone numbers belong to, what these cell phone numbers could possibly reveal. They ought to be allowed to come into court with more information than just a document with some cell phone numbers listed on it, asking the court to require a cell phone company to shorten the length of time that they have to respond to a subpoena. Now, if they articulate a reason, and they can articulate a legally recognizable reason that these cell phone records may relate to the claims and defenses of this election contest, and that's maybe a more different color. But as we stand right here today, those reasons not being articulated. The court, I don't know, and I don't think the court has been providing any information as to who these cell phone numbers belong to, or what the purpose of them trying to get these cell phone records are. So we would object to the cell phone record subpoena. Secondly, the motion to open the ballot box. I know the court probably saw a lot of this played out over TV. The court watches TV.
I have not watched any of it.
Okay. But these plaintiffs did a procedure called they canvassed the ballots. And that's a procedure that's recognized under the statute that allows a candidate to go in to look at the ballot boxes and the ballots and all the material that are in the boxes. These plaintiffs, conducted their canvass over a total of 5 days, sometimes more than 8 hours a day. They had an opportunity at that time, Your Honor, to collect all of the information they wanted to do that. That statement I just made is supplemented by the fact they filed this complaint with a hodgepodge of accusations and allegations, none of which will affect the outcome of the will of the voters of the city of Hattiesburg. All right? So they want to go in and they say the purpose of it is, the sole purpose is making copies of trial. Now, I understand that. I think the court, if you allow them to do that, they ought to specify what precinct boxes they want to look at. They shouldn't be allowed to say, we want to look at all the precinct boxes, because I don't think all the boxes had affidavit ballots. And they ought to specify the materials needed. The law has a reason, Your Honor, that after canvass, they had opportunity to canvass, we had an opportunity to canvass. Our canvass was much more reasonable than their canvass. After the canvassing takes place, the law mandates that the clerk lock the boxes if there's an election contest that has been filed. We were notified by the plaintiff that they would file such an election contest, which is why we're here today. We really don't think those boxes ought to be just wholesale open to these plaintiffs' whims without the court putting strict, confined parameters. How long are the boxes out to be open? How long must the clerk be there? There was sometimes, Your Honor, on Fridays and late in the evening, we were up here, had individuals up here looking at the plaintiffs as they continued their canvass. So this process could be expensive, it could be time-consuming, it could be cumbersome if the court doesn't put any kind of parameters on these plaintiffs. Lastly, Your Honor, they asked that a motion be granted ordering the city to preserve a certain amount of video. Now, I understand why they want the video preserved, but the logic behind it is absent. They are trying to make the allegation that there is a 45-minute segment of video that is somehow absent. And during that time, some mysterious person came in and messed with the ballots and actually stole the election and a lot of other kind of stuff that's involved in their complaint. The absent video, if the court makes us order to produce it, we will, I think it would just give the certain clerk to be sure it's there to preserve that. And we understand why they may want that. And so, if the court puts parameters on what these plaintiffs are asking for, we think we come to some kind of conclusion. We want to work amicably with these folks, but we don't think that they ought to be just wholesale allowed to get this stuff without any kind of parameters. Thank you, Your Honor.
You can't be very much.
cell phones, Your Honor. These are what probably would be public records if we were in that venue. We believe that we have the right to go ahead under Rule 26 to not only find information that's relevant, but other information that might lead to relevant, discoverable information. So we submit that we have.
Who are the phones listed?
These are the numbers that were provided to us by the city clerk's office as to city employees.
City employees in the clerk's office?
City employees, Your Honor. These are city phones that are paid for by city public funds.
Go ahead. You don't know those individual names of the employees?
One moment. Your Honor, these are people that are acting or were, in fact, assistants working with the mayor that were involved in the campaign. There are statutory prohibitions against people using while they're on the clock with the city, actually campaigning at the same time.
Well, this is no matter. Does that have to do with where the votes are?
I'm sorry?
I said, that's another matter. I don't know that it's proper in this particular case, but I think you're entitled by way of discovery questions that have some indication of there, but let's keep limited to that.
All right.
The fact that they may have violated some rule or so forth, nothing to do with affecting the outcome of the election.
Your Honor, if you see the need for the protection of the city, since this is city property, city phones, we can have this submitted to the court in camera for you to review and determine if there's anything that shouldn't be disclosed for any sensitive reason.
Okay.
Your Honor, as to the issue of, as Mr. Martin referred to it as a canvas, it's not a canvas, it's an examination of the box. You use the word canvas, that's what the election commission does when they review affidavit ballots and other ballots. But as to the examination of the box, we are well willing to provide our own copy machine, our own paper, and our own staff to make the copies in the presence of the clerk. So the city clerk can go ahead and make assurances that no ballot, no election material, no application, nothing at all, if the document that's in that box is altered, changed in any way. We're strictly just trying to go ahead and make for ease of this case to move forward, so the jury is not sitting there for long periods of time, literally hours, for us to go into the boxes, pull the ballots out, introduce them to the witnesses. This is just standard trial practice to be able to prepare pretrial exhibits. We have spent a lot of time going through this, and we know exactly what we're looking for, and it will take us long to do it.
Let me interrupt you. If
Yes.
you know what you're looking for, why can't you designate which boxes you're interested in?
We can, Your Honor, but I want to tell you this, that I'm told that the absentee ballots that came out of certain precinct boxes have not ended up back in those precinct boxes. So not knowing exactly what boxes they're in puts me at a bit of a disadvantage. They were all combined together, the absentee ballots, run through the machine for counting purposes, and then they were put back into a box. So as long as we're able to get to those, whatever boxes that may have.
Does anybody know what box they're in?
Well, I would hope that the clerk would, since the clerk is charged by law to maintain the security of the ballot boxes, to maintain seals. So